So, good morning, everybody. I'm afraid we are so few people, but I think we have to be the best ones. Okay, okay. And we have the pleasure of having here today Professor Jussi Tapani. Professor Jussi Tapani is Professor of Criminal Law at the University of Law in the Faculty of Law in the University of Turku, and he is as well the Dean of the faculty in the same university. Let me say that I first met him some years ago when I invited him to a one-day meeting on cyberfraud, you remember, of course. And there was because we were working in the framework of our research project, which was then in progress. Later we have done some useful collaborative works together, so I can therefore attest to his great commitment to the university life. Now shortly, I would like to highlight just certain points of his CV. He has been researching in universities of countries as Germany and Sweden. He has led and supervised many research projects, such as one on the theory of interpretation in criminal law, another one on intentional fire-related crimes, another on criminal liability of sport fraud, on serious fire-related crimes and frauds, another on occupational safety crimes and corporate criminal liability, which is very close to the topic of today, and another title, How to Rule the Economy. He is well-known author of publication, and the scientific and societal impact of his research, it's clear, among other reasons, because since 1999 he has been lecturing regularly to audiences consist mainly of prosecutors, judges, advocates, and police. This further education is organized by the Faculty of Law of University of Turku in cooperation with courts, district courts, and the Court of Appeals, and the Finnish Bar Association and the Ministry of Justice. He has been regularly interviewed by the media, both in Finnish and Swedish. He can speak Finnish, Swedish, German, English, as you can see. So I don't want to bore you with the details of Jussi Tapani's excellent CV. Let me only say a few words on the topic that he's going to speak about. So the presentation will have two parts. Firstly, he will discuss, as you know, about corporate criminal liability in Finnish criminal law, and describing the content of legislation and the structure of liability. And after, he will show us some practical aspects and show us some research findings. So, welcome Professor Jussi Tapani on behalf of our Faculty of Law on our university, and without further ado, I give you the floor.
Thank you.
Welcome.
Thank you very much. I was preparing the presentation, short presentation in Spanish, but I think there are people only or mainly English speaking, so I don't start with this small. But anyway, buenos dias. Buenos dias. It's a pleasure to be here, and thank you very much for this kind invitation and presentation of myself. We Finns, we don't used to get that nice presentations of ourselves. Thank you. As it was explained, I have two parts in my presentation, and I'm not sure how long do we have time. 30 minutes, and then discussions. I think we will have this quite informal occasion if it's okay, because I prefer. So please interrupt me, ask if there comes up any questions during my presentation, and then we can continue discussing. Actually, this presentation is based on mainly on still ongoing research project which deals with safety or occupational safety crimes and corporate criminal liability. I have myself written mainly on this normative perspective, in interpretation and systemization of norms and the whole project is led by Professor of Sociology of Law, Anne Alvesalo-Kuusi, who is a criminologist, regularly visits Spain also, and mainly Britain, and who is very well connected to Canada. He is lawyer, but does mainly criminological studies. So we are working together on part of her project, and we have other collaboration too. So first, normative perspective, something about legislation and structure of liability, and then well, not only tentative results, quite actually good results about this empirical perspective. And to start with legislation, I will focus on Finnish criminal law, and I don't go detailed into these different sections, because as we know, the Google is our friend today, so just put Finnish criminal law or Finnish penal code into the Google, you will find the unofficial translation of Finnish criminal law and see more detail what is behind of what is the wording of legislation. But we do have the one chapter which is question about criminal corporate criminal liability, CCL, it is abbreviated here, as normally scope of application, and then this structure of liability or prerequisites of liability, and also sentencing, how to define amount of fine, because for the normal offender, for the human beings, perpetrators, there is a separate section, a chapter for this sentencing question, but for the corporates it's incorporated to this chapter, and then some procedural aspects also is included into the chapter 9 in Finnish Criminal Code. What about then? I would like to highlight some normative aspects which perhaps tell about the basic decision made by Finnish legislator parliament, because we know that there are different solutions in European perspective what concerns somehow regulating corporations. Is it then criminal law aspect? Is it more or less administrative law, civil law system? Is it called punishment or other sanctions? You do not have any solid solution at the European level. Even between Finland and Sweden, our neighbor, we have very close connection, and even the structure of penal code is quite the same. You can find argumentative support from a Swedish criminal code called brottsbalken. But when you go to the corporate criminal liability, it's totally different. They have chosen the different solution in Sweden, for example. So that's why I haven't focused on any comparative perspective here, but we can discuss, of course, after that. So prerequisites for liability, they are incorporated into the first three sections here, And firstly, the scope of application is quite wide in Finland. It is mainly stated that a corporation, foundation, or other legal entity. It is mainly firms. They could be in somehow big multinational companies like Nokia in Finland, or other oil companies, Neste, Forum, or very small one-man's or one-woman's company. But even public entities, and the only limitation is this kind of, when you are fulfilling or exercising a public authority, because there we have decided that there must be somehow other forms of liability. It's hard to get municipality, city, or even the state organs, and I don't any good cases in Finland where the court should have tried to interpret this line between exercising public authority. The cases are normally they are private organization, corporations, and so on, limited companies, and so on. What about then this normative structure? It is somehow, this is the most difficult part of our legislation. You have twofold, something like, I could call it twofold system. First, you have to have, or I should say that the organization or this company is a context. It is social legal context where the crime is committed. It is as an organization or company understood consisting of normative structures, practices, organizational culture which form this environment for committing a crime. But in Finnish system there is a human being who is a perpetrator. You must find and somehow put the liability. You have to find. It's not the corporates as such who commit somehow the crime, and I think this is the way we somehow understand. I know there is a different theoretical perspective on organization, how to in firms theory and so on, but in criminal law context this is the foundation, and that's why we have decided that there is mainly three different form of liability. Either you are deciding something, you make decision as a CEO or a member of board, making those decisions which somehow are counted as a company's decisions, and that's an accomplice in an offense. That's the one form. Or somehow allowed something to be done, to be committed, and one of the difficulties is that these two first forms of liability, they refer to intent, intentionality in criminal law sense. And most of the crimes which are committed in Finnish, they are punishable either negligence or gross negligence. So how to incorporate this is there is no discussion, no real discussion, theoretical discussions. We discuss a lot about intent. It is the one of those classical questions in every European criminal law theory. In Spain, well, certainly in Germany, because when you find a nice piece of Festschrift for some professor, you will find this one certain specific Festschrift in 2003 where there is article about intent, and you find a page and then start opening the page and it is put into the 10 pieces, and actually then in Festschrift book there is one page which is like this. It is yes, about Vorschrift, Vorsatz. Yeah. So how to incorporate this discussion about intent of sole perpetrator into the corporate criminal liability and intent. So this is more or less theoretical discussions, but the most important is this third one, which is called or written in Finnish criminal code, is the care or, let me see, due diligence or diligence necessary for prevention is somehow they haven't succeeded in the company to fulfill those demands, and that's why, for example, safety crimes, environmental crimes, they are punishable under the, or even in gross negligence, committed by gross negligence. So they are the main core application scope in this respect. What about then some extra prerequisites? Let me see. There is one possibility called anonymous liability if you don't find or you don't or you can't prosecute a human being as a perpetrator. He may have killed, maybe dead. Somehow procedural evidence aspect is so difficult that you can't put blame, or you have to just drop the case against. But you are certainly aware of that it's corporation which is the environment where the crime was committed, against nature, against safety of workers or something like. But I don't in our empirical research, I don't know any cases where this formal liability could have somehow tested. So it's basically the first two one, and this diligence gross negligence form, which is applicable. And then something else. Finnish legislation has chosen that there must be a certain link between the corporation and the offender, and somehow it is thought that this crime should be for the organization, made for, not against. But when you look a little bit deeper, it's not. It's never for a corporation, because a company is affected by the negative public publicity, must pay different sanctions, but somehow you have to find a balance between, and it is thought that there could be different links. Either you are representative as a CEO, as a member of board, or work at enough high level, able to choose and or direct the company's strategy or something like, or perhaps you have get a task to fulfill some independent services. So this is basically three different forms of liability: complicity form, or complicity in normal criminal law, or then allowing something, or then this diligence for an anonymous as an exception, and then a certain specific link between corporation and offender. Now I have used almost 15 minutes, and shortly about corporate fine, because it's question about is it effective enough. Corporate fine between 850 euros up to 850,000 euros, and compared to, for example, UK level of corporate fine, this is peanuts. This is certainly peanuts. If the company who is somehow, for example, destroy or chosen not to fulfill certain environmental obligation, destroys or endangers the nature, the lakes, the lake city, the forest city. We do have a case now on in process in not northern, it's northern east in the mining area, and it is hardly to fair enough that if the corporation will be punished under this section, it's environmental crimes, 850,000 euros will be somehow in just relation to the crime which was committed. It's now in the Court of Appeal. So as you see, the highest amount of corporate fine has been as far 500,000 euros. It is suggested that it would be 3 times bigger than, but it doesn't go through because our government chose a wrong line. There is question about fines in traffic offences, and this is a short side trip now. They wrote into the bill that this bill is targeted, or we aim to collect money to the state with with making fines in traffic offences higher. It's fiscal. They wrote into the governmental program when the new government started that we try to collect money. There is always need of fiscal fee, and it went to the constitutional. We don't have a constitutional court, but the parliamentary, and they tried to find some other arguments, but didn't succeed. And I think I'm lucky about that, because it's somehow against very basis of criminal law. You don't collect money. You collect with the fiscal law and other instruments. Of course, there is something to do with the criminal justice system, with the economy and fiscal things too. But it was a huge, and sadly also this bill or regulation trying to make bigger this corporate fine, it was thrown away at the same way. So this is about I have discussed about this reflection committed by human being. Corporation constitutes a social legal context, and certainly there is needed more research at European level, but especially in Finnish criminal law research. Then shortly about I call it implementation. What do we know about cases? Because this is only normative structure. What do we know about cases which somehow go to the criminal investigation, then to the prosecutor, and end up to the first level of court? And we have had and still have a research project at our faculty, and there is aims. There is actual two aims. One is about more or less question about sociology of law, and try to find who were the most powerful actors of somehow affecting the content of this corporate criminal liability at legislative process. It's a question about power, and who can somehow affect, and it is, well, narrative method in a very short way to say. And then what do we know about these court decisions, about cases, kind of cases they are, what is the amount of corporate fine, who are the offenders, and so on. And a couple of pictures. These are somehow put together from the official statistics and from our sources, and as you see, in a couple of years, not very many cases, and even more surprisingly, most of the corporate criminal liability cases, because there are now, it must be, now I don't remember exact number of offenses where you can use this corporate. You can't use to any every single offense in criminal law. They are more or less crimes which are somehow where the corporation is forms a natural environment for committing crime. Most of those crimes are safety crimes. Some of them are environmental, and there are a lot of crimes where, in principle, it's possible to use this kind of liability, but is never used. What about then? Who is punished? One of the main findings or claims of our research team is that it's offenders, it's human beings who has the biggest burden on this punishment. It's not corporations as such. And it's question about justice in the criminal law system. Should it be offenders, single offenders, based on different position in the corporation, or more or less legal entities who carry on this burden? And then who is convicted? 161 cases, and now I have to point out here this in 6 cases out of 161 only corporation convicted. It's it may be those anonymous liability, but actually it is cases where they somehow, for some reason couldn't find the offender as guilty, but could somehow, based on evidence, be sure that it still the crime was committed in the operation of there were suspected person, but couldn't convict the person. These are not cases of anonymous liability as such, and we could find evidence for the assumption that in principle or even in empirical perspective, this responsibility is somehow found or put on the lower and middle level of organization. It's not those who decide the strategical lines or structure of organization or allocate resources who would bear on responsibility. It's more or less those who are at the floor level and do not react, and then we can ask in the criminal law case, do they have possibility and capacity to react and somehow get things done right. And lastly, about the average corporate fines, it is fairly low amount of corporate fines. As you see, 10,000, a bit over 10,000 euros. It's not very high, because you have 850 euros up to 850,000 euros, and that's one of reasons why the government wanted to make this higher because when you write the minimum, or perhaps not the minimum, but when the maximum will be third time bigger than, it is the message to courts. You have to convict a bigger amount of fines. It's clear message. This is how the system, at least in Finland, functions. That if the legislator wants to affect on the case law, it has to send clear message in a governmental bill that now high maximum of sentence for the human, normal, or even for the corporations.
Sometimes even could be worth it to commit a crime.
Mm-hmm.
Could be because.
Mm-hmm. That was basically what I wanted to tell you from the empirical and
Okay, thank you very much.
Thank you.
So, is there any question? Yeah, 2 questions. Then-
Congratulations for your lecture. It was really very clear, and I enjoyed it very much because I have researched about the topic. And in Spain, as you probably know, we have a regulation of the criminal liability of legal entities which comes from 2010. So it was recently introduced in the penal code. And our first essential question is, when does the regulation exist in Finland?
More or less, yes. The exact, I remember even the exact year. It was 90s. It was 95, and first 8 years there were totally 4 cases in Finland. During 8 first years, 4 cases, and one of the discussions was that did we somehow or do we have in Finland a form of liability which is somehow borrowed from the Anglo-American way of thinking, that corporations are, that do we have such kind of corporation where this is the natural form of liability, and that's one theoretical question. But I think the right answer is that prosecutors were not very eager. It means more and more work, even for the police. They have to investigate new different aspect of crime, different gather different or more evidence, go deeper into the organization's decision making and structure, find more different kind of who will do that, what is the delegation, who decided, and it's I think they saved didn't want to do so much, but then it was question about discussion and somehow guiding question about also lecturing and so on, educating more and more, and public pressure also.
That's really interesting because, as I say, in Spain there was a big debate before introducing the penal regulation in the penal code, because many of the scholars, many of the academic writers, they were against the criminal liability of legal entities, according to this Latin saying, "Societas delinquere non posses," which is still in force in some countries, for instance in Germany, as you said, they do not have criminal liability of legal entities. But that's very interesting and exciting to know that many countries in Europe, they have criminal liability of legal entities, and the regulation is similar, broadly speaking. Although in Spain it has been criticized because we the regulation of Italy, which is really very flexible. And even though it is possible that we will not apply the regulation up to some years later. I mean, it's really difficult in Spain also to apply this criminal regulation on legal entities, because we also have since 2015 this possibility of exemption of criminal liability, which is called the compliance program, or programs about the organization and the monitoring of the responsibility of the officers who are on charge of preventing the commission of crimes inside the legal entity. So I don't know if it exists also in the regulation of the Finnish criminal law. Is it possible to exempt from criminal liability to legal entities when there is one officer who previously accepts to organize the company, to monitor all the aspects of the accountability, so that actually he's going to be the person who is going to be accountable for possible liabilities of the...
This is very interesting question, because firstly we got a new regulatory system in Finland, you know, the plea bargaining, for some years ago, for sole perpetrators and offenders, and it was a huge debate. Is it somehow a natural part of our legal system, because there was a lot of discussions, and now we know, for example, that those big drug cases are accepted from they are out of scope of application, and those are the cases where it could be very effective. The Finnish legislature made certain restrictions, and I wrote in article that should it be possible even to apply this plea bargaining for corporations, but you don't find any clear answer in legislative material. What comes to this compliance system, we don't have any. You could somehow integrate this kind of system into the section or this chapter 9 section 6 waiving the prosecution or something like that, but it's not at the moment integrated in the. But the main point under the Finnish criminal law thinking is that the result of conviction based on corporate criminal liability is the message to the organization that you have to change and rethink and restructure your decision-making system, monitoring. It's the main thing, but because it's over 20 years old system, we perhaps didn't have followed up the newer discussion, but that's.
But it's incredible because in our country, in 2010, it was introduced for the first time the criminal liability of legal entities. So we had in 2010 a similar regulation to the Finnish criminal law. However, only 5 years later, in 2015, it was introduced this compliance regime or compliance system. So in a short period of time, we have the possibility of punishing criminal legal entities, and 5 years later, we have an incredible extension
Mm.
cases in which there is a compliance officer or somebody on charge of the responsibility for the commission of requirements of the legal entity in the profit or in the benefit of the legal entity as in Finland. So only in 5 years we decided to more or less annulate or make null and void the previous legal system. It's really shocking for us, and it has been criticized in our country. In countries like Finland, you have more or less the regulation that we had in 2010.
Yes, and I yes, and I
Differences, but
yes.
more or less it was the same. And 5 years later, we have a broad possibility of exemption of criminal liability. So I think that the legislator in Spain almost killed the criminal liability of legal entity system in 5 years, because there are so many possibilities of exemption of criminal liability that at the end we don't know who is going to go to pay for the offenses committed by legal entities.
Yes, because it affects the foreseeability of this application or interpretation of these statutes. Who would be then? It's quite random chosen based on different. It seems or sounds for me that in Finland, this criminal justice or criminal law discourse is stronger than civil law discourse, this company law, because every time when we get new legislation from the European Union level, somehow harmonizing new type of crimes, money forgery or different aspects, new. Every time, as you know, there is the one paragraph you have to have effective and also somehow corporate liability in different way. And in Finland we put all the time, okay, this new type of offense, yes, it's very good for the corporate criminal liability, and one paragraph at the end of the chapter for new and amending or widening the scope of application, and nobody is somehow against. Is it a really good way of doing? Is it suitable crime for corporate criminal liability? So, but on the other hand, it sounds that when it's quite new one, it seems to be easier to get this civil law discourse into the legislation somehow.
Yeah, the influence in Spain, I think it comes from the American criminal law system of the common law. Compliance programs are not directly implemented following the guidelines of the European Union Pact, following the doctrine of common law system of the United States. And there are many offices of lawyers in Spain, companies that are working in compliance programs, so that this is a business also, because of course,
Yes,
as
I understand. Yes.
As you said, the sanctions for legal entities are not very high, neither in Spain. I mean, if we consider that some companies, they have the PAB, of one country sometimes, or the benefits of some companies are equal to the PAB of some country. So if you impose sanctions that you say 8,000 or 800,000 euros, well, for a company who is earning millions and millions of euros, probably Nokia and some other countries, it's
Yes.
really a joke. I mean,
Okay, so another question.
No, because that leads on to a question I wanted to ask. Because we've got data on the average amount of fines, and we've also got data on how many convictions are closed. Very few. But my question was, do we have any data correlating the economic capacity of those that were fined?
Yes. We have. I think we have now published some of articles in international journals, they are mainly discussing about this first part of empirical studies about these powerful agencies, or who are affecting, who was able to affect and define the content of, and these results are mainly published in Finnish journals, and we made there are a lot of statistics, and somehow there are, of course, it's both normative reasoning and empirical reasoning. Question about there are certainly firms who are economically very weak, and in those cases the courts tend to think that it's no use to burden them with corporate fines, because they are not capable. But this, for example, this 500,000 euros for the Neste, or nowadays for Neste, which is oil company operating in Finland, also in Russian, is a very economically strong company. I don't remember exactly those correlations, but certainly the amount of corporate fine is in no way in just relation to compared to normal preparation, and even for the normal fines, because we have still the system in Finland. Now it's proposed that we should have the normal European, that it's based on the let me say two aspects: the gravity of offense based on the number of fines calculated 2 days, 4 days, and then economical. And if you are a millionaire, you will pay 100,000 euros for just speeding 25 kilometers. You just and it's in some way it's not related.
And in connection with that, is there any evidence at all? I don't know if it would be relevant on kind of forum shopping in that case, meaning that if you're a British firm that might be tempted to commit a certain type of offence, it should be worth your while moving to Finland, knowing that the fine will be much lower. And also, sorry, just on the question of fines, are fines determined ever in the system by jury, or is it the judge examining the law and applying the suitable fine? Because in the American system, for example, I'm just invited to do a lot of criminal law specialists, but I think there are some cases where juries have some influence on the outcome. And the last question was, these fines, I imagine, also might coexist with civil responsibility. If there was an environmental case, then I imagine that the company has to make reparations.
Yes.
Reparations.
Yes. The last, I start from the last, or with the last question. Sorry, now I.
It coexists.
Yes. There is a large or wide and large structure of regulation concerning environmental sanctions, which is somehow between administrative law, civil law, and environmental law, to put the nature, or as it was before. I don't remember the word in English. It is somehow recovering those damages and somehow to find solution where the lake are are made as they were, or put different physical and biological organisms into the lake and so on, and they might cost a lot. So they are in somehow the total cumulation of sanctions may be really huge, and that concerns even the case which I mentioned in northeastern Finland, the mining company. It is now in bankruptcy proceedings based on different sanctions. Also, of course, the economic capacity of firm. What comes to next question? It's nowadays at the moment mainly judge, because we used to have a composition of judge and 3 laymen, but the Finnish government wanted to spare money and put more and more cases to one judge decision, or somehow, or in some cases three judges at district court level. In Court of Appeal there are 3 judges. Forum shopping. No evidence, but when I or Professor Anne Alvesalo-Kuusi mainly have discussed, I have also followed the discussion. This, for example, UK. In UK, they are very somehow not very informal. They find new solutions and even use the words which are unfamiliar with our system, because they have a regulation, if I understood right, and it's total norm to talk about corporate manslaughter. It's totally unfamiliar with Finnish system to think about that. It's corporation which commits the manslaughter, and different aspects, and also the amount of corporate fine. 300,000 euros is quite average for a quite small, or in Finnish perspective, small crime in environmental, or especially in safety crime. So, but no evidence. But our system is, in criminal law perspective, quite lenient. Certainly it is.
Just one final question. Sorry, I don't want to ask too much, but is it possible to apply this criminal system of liability for legal entities to any crime, or only to particular crimes? Just ask it because in Spain we say that we have a numerous clauses system. We only can apply it to certain crimes, environmental law, crimes against the exchequer, or some crime, bankruptcy, some particular crime. But in Finland, is it possible to apply to any crime of the...
No, not only for particular crimes where it's stated, or yes, at the end of normally at the end of paragraph. But and that's why, for example, the safety crimes, they were not originally included into this system, and that was due to huge criticism from the representative of powerful organizations and powerful employees, big firms, that it's no way useful to have that kind of liability form in safety crimes. But it is slowly reaching more and more crimes.
Political parties can be charged with
Interesting.
Sorry?
Political parties can be charged with any responsibility as
No,
as
no,
an
no.
Well, it's a matter of opinion right now, but
It should be, yeah, yes. But of course, it is possible. No political parties, but if the political party has a company which somehow is doing normal business,
Because it's a corporate,
it is associate. The form of organization is association, and it's not having public authority as such. It is totally possible to have those
Because it's
politicians responsible. So they are not totally, but those are quite. And normally they are accused as a single perpetrator or offender for fraud or whatever economic crimes, corruption and.
I just want to ask, have any financial institutions been charged with
Yes. Or let me see. We have had. How do you define financial institution?
Banks.
I mean, that's the question. For example, any banks, any shadow banks like intermediaries that deal with things like securitization or industry, or any hedge fund perhaps?
No. They are mainly. There have been cases which deals crimes committed in financial markets, manipulating the stock, the price of stocks, or giving false information to markets, and a responsibility for those CEOs, and also the corporate criminal liability. But it hasn't been question about financial institutions as such. It is mainly question about civil responsibility. For example, now lately quite big case against a bank called Nordea, which is Nordic operating. Actually, the headquarters is in Stockholm, in Sweden, but it's originally, it's situated in both countries, giving false or misleading information to those customers who are putting their savings into the different savings instruments. And yes, it's more or less, and it's question about who is actually giving the misleading information, where the decision has made. Is it more or less those who are behind the desk giving information for older people, for example, who comes and asks, what do I do with this money? So, as far as I know, no cases against financial institutions.
Okay. Is there any question else? No? So, many thanks. Thank you so much, and we hope see you soon again in Spain. Okay?
Certainly.
So?
I promise to come.
Promise to
Thank
come?
you.
Okay, thank you.